With legal realism, we're looking at a different school of jurisprudence. Here, this view of analyzing the law, looking at what the law really means, started in the 1920s. And here we say we have to look at it within a social context. So, for example, unlike the positivist school, whereas we're just going to say this is the law of the land at this point in time, we're now going to be able to say, for this point in time, is this the best law that there is? Meaning we would look at slavery within the context of the Civil War, within the context of what's going on historically, etc. So we're not taking the law outside of society. We're keeping it firmly rooted in social context. So judges look at economic social realities. This is the type of jurisprudence, if someone follows this, where we tend to talk about activist judges. In other words, judges look at look at society and see if things are not quite what they should be or where they should be, and then they will kind of craft some of their decisions in order to allow a broadening of certain rights. For example, the civil rights decisions, these all came out of initially Supreme Court decisions, and then the legislature, Congress, caught up afterwards. Here, the courts usually don't feel bound by past decisions. In other words, they don't really look backwards and say, well, this is what we did 50 years ago. This is what we did 100 years ago. They say, right now, based on what's going on in society, what is the best way forward for us? There's a belief that the law is less important than who is in the position to enforce it. So in other words, we're not elevating law to this esteemed example of if it's illegal, it's automatically okay. Here's where we start saying, hey, we've got a law, and when we look at it and we start applying it, we say, yeah, there's a problem with it. So we need to change it because it's not really impacting people or being as effective as we thought it would or should be. Critics say that judges should not be using any outside factors. They should be blind when they're looking at facts and not saying things like, well, this was a homeless person, or this was this type of minority, or this was a disadvantaged person, or this was a very wealthy person. They shouldn't bring in any of that. That's one of the things that does come into play with this, is that judges do look at those outside facts. Critics say, no, you should just look at the law and apply it. Proponents say laws are written in a vacuum. Things that happen in Washington, D.C., things that happen for most of the congressmen, they are not your run-of-the-mill average middle class or poor people who are living reality. They have a little bit different theoretical approach, and so we need to kind of adjust things and take that in consideration when we are deciding as judges, when we are deciding opinions. And I originally would ask, come up with some examples, but I've already been giving you a few. And then there's been a few things that are already in the news, that have been recently in the news, showing how this jurisprudence comes into play quite a bit. We all know about Roe v. Wade. Well, we at least know that Roe v. Wade deals with abortion. You may not know the exact facts of it, but Roe v. Wade is pretty specific in saying when abortion is legal, when it's not. When it is made legal, there are very few restraints that can be put on it for a certain time frame, and the case is very specific about when you can't put, a state cannot put restraints on abortion, and then when it can. And it really kind of breaks down into the trimesters. I'm grossly simplifying this at the moment, but basically the first trimester, a woman has a right to an abortion. The second trimester, the state has a right to step in and say, this is when we're going to allow abortion, this is when we're not. Third trimester, the state has absolute authority and is the final arbiter. So they get to decide whether they're going to allow abortion or not, and whatever exceptions they'll put to it. Versus what's now going on today. Notice this Roe v. Wade was 1973. So in 2013, we're still debating this. Things are going on in Texas. Governor Perry and notice this was July 18th of this year, signs the new abortion bill. Puts very, very restrictive measures on abortion starting at the 20th week. And it's right at the moment when Roe v. Wade is a little bit unclear of whether the state has the authority to do this or not. And so immediately people have been challenging it. And it will end up going to the Supreme Court to have to look back at Roe v. Wade, most likely, to say whether Roe v. Wade is clear enough to say when the state has the authority and when the state does not. But the idea is that here, Perry is saying, and the state legislature of Texas are saying, we want to make the law. We don't like abortion. We're going to say, and this is one of the positive school, we're going to say abortion is not good from our moral compass. Our moral compass is out of sync with what the Roe v. Wade allows. So we're going to bring the law into sync with our moral compass. Then others are coming back saying, no, just because this happened in the past, you don't get to say, this is how we're going to look at this, or we're going to change it, or we don't even take into account necessarily this is just because what you want. We need to look at the bigger picture of what's best for women and children and families, right to choose. So this becomes a culture war. And that's what opens it up in the second school of thought and creates a problem. And so we're seeing a lot more because we're a lot of the judges now are into this allowing to look at different aspects and kind of peeking through the blindfold to the scales to kind of weight them one way or another. And then we see legislatures trying to bring things into tune. In some places in the South, it's conservative, so it's moving. In Texas, for example, they have a conservative legislature, conservative governor who's trying to bring some of the liberal laws into a more conservative arena. But then we also get the flip side recently with Colorado and Washington legalizing marijuana. They felt the marijuana laws were too conservative and they're more liberal, so they've kind of shifted the laws to match the liberal aspect. So we see this, and this is what the judicial activism calls into play, this idea of the culture war, because we have people wanting to trigger things for different reasons. We also see this in Lawrence v. Texas, which is a case out of Texas again, where sodomy laws in the U.S. were found to be completely unconstitutional. Sodomy being oral or anal sex. And the sodomy laws that are on the books, and that were on the books in almost every state, deals with no particular group of people. It just says sodomy is illegal. So whether you were male, female, husband and wife, boyfriend and girlfriend, two gay men, two lesbians, whatever your sexual makeup, whatever you were practicing. If you, for example, prior to 1996, most states had sodomy laws, so if you were engaging in oral sex, you were doing something that was against the law. Generally, it wasn't enforced except against gays, gay men specifically. A case went up, finally with Lawrence v. Texas, it was decided that, because this does impact into marriages, which is considered a very right to privacy arena of the Constitution, the state doesn't have any right to say what type of sex you're having as long as it's consensual between two adults. And so sodomy laws were struck down. Recently in Virginia, over the past couple of weeks, notice this is coming from August 9th, Virginia Attorney General has been trying to reinstitute new sodomy laws. Well, Virginia never took their sodomy laws off the books. When Lawrence v. Texas came about in 1996, instead of the legislature going in and invalidating all these laws, they just kind of left them there. And so the Virginia Attorney General has decided that he'll just reinforce them. He's just started arresting people again. It went up to a 3-panel Fourth Circuit Court of Appeals, and they said those laws are unconstitutional. We said so in 1996. Get them off your books. The Attorney General in Virginia then appealed to the Supreme Court and said, we're trying to litigate this, so you need to give us time to figure out what's going on. And the Supreme Court, Chief Justice John Roberts came back and said, no, this is very well settled law as of 1996. You need to kind of get up with the times. You cannot go out and arrest people for sodomy as long as it's consensual adults. So we still see some of this type of jurisprudence, and we see a lot of it, actually. This is where currently we are in our mindset in the U.S. There's a natural law school that assumes that everything is based on universal principles, that if we think about them, we can figure them out. This is the oldest view, and this was the view that our Constitution was written under, and the Declaration of Independence, because Jefferson refers to these as the laws of nature. And if all we have to do is think about what nature does, and then we can figure out what we should be doing based on that. This creates a whole different slew of problems as well, as your book talks about some of the issues. And then finally, there's the historical school that says, well, we really need to kind of look at law as an evolving thing over time. That basically the legal system in the United States really started in 1789 and has evolved since then, and we can't just throw things out because we don't like them now. We need to keep it so that we realize and can look at these. For example, we don't just want to invalidate all of the laws that were on slavery and forget about those, because people, again, we can see with abortion, I don't think slavery will ever happen again, but the idea is that, abortion and sodomy laws are well settled, have been for years, and suddenly this year people are deciding they want to reinstitute some things. So the historical school says we can't forget what we've done, and we've got to keep it out there so that people know not to go back and repeat the mistakes of the past. And so we follow earlier case law. Whatever judges have done, as long as we've seen that it's good law, we'll follow that. And that system is called stare decisis. We'll look at it a little bit later. And so for this last bit, I'm going to start a new YouTube video. It'll take about 10 minutes, and we'll look at the historical information of where our legal system came from.